Litigation is a two-way street, and right now it is Fox News' turn to strike back, or as we should probably say, slap back.
Baby glow, slap.
You'll get the joke if you watch this vlog.
Viva Frei, Montreal litigator turned YouTuber, and there is an update in the newly filed $1.3 billion defamation lawsuit that was filed by the name that cannot be spoken against the names that cannot be spoken.
Inconceivable!
I'm joking, kind of, but not really, but one of the defendants to the lawsuit was Fox News for the coverage they gave on the issue at the time of the election. Well, Fox News just filed its own motion in this lawsuit, and it filed a motion to dismiss. It filed a motion to dismiss on the basis of anti-SLAPP legislation. And for those of you who don't know what anti-SLAPP legislation is, it is SLAPP, strategic lawsuits against public participation, lawsuits that are filed for the purpose of silencing people. Lawsuits that are filed against people or entities in order to silence them in the exercise of constitutionally protected rights. Anti-SLAPP legislation is jurisdictional. It will vary from state to state, and we did actually come across the anti-SLAPP motion to dismiss question in Nico Romeo Lacoste's lawsuit against Keemstar. Now, for those of you who may be unfamiliar with the facts in the Nico Romeo Lacoste lawsuit, go check out my previous vlog on the issue. But bottom line, in that lawsuit, Nico Romeo Lacoste was a world famous tattoo artist. Keemstar has this channel called Drama Alert where he reports on dramatic things on the internet. He called Nico Romeo Lacoste some bad words, which we will not repeat here. Nico Romeo Lacoste sued Keemstar on the basis that he damaged his reputation, damaged his business, etc. Keemstar filed a motion to dismiss on the basis of anti-SLAPP law in the state of California and succeeded. Keemstar argued that he was merely exercising his First Amendment right to freedom of speech, and that the lawsuit filed by Nico Romeo Lacoste was an attempt to suppress his exercise of constitutionally protected rights, and that it should therefore be dismissed under the anti-SLAPP legislation in California. Well, in the context of this multi-billion-dollar defamation lawsuit, this is exactly the same argument that is being raised by Fox News now, but this time under the laws of New York. Supreme Court of the State of New York, County of New York. Memorandum of law in support of Fox defendants' motion to dismiss pursuant to the First Amendment and CPLR sections 3211 A1, A7, and G. Choice of jurisdiction is always important, and from what I understand, not every state has anti-SLAPP legislation, so when choosing to sue for defamation, for example, you might want to consider not suing in a state that does have anti-SLAPP legislation. CPLR is New York State's civil practice law and rules, and they have specific provisions for motions to dismiss, and they have specific provisions for motions to dismiss based on anti-SLAPP legislation. And the provisions on which Fox's motion to dismiss are based read as follows. A. Motion to dismiss cause of action. A party may move for judgment dismissing one or more causes of action asserted against him on the ground that 1. A defense is founded upon documentary evidence, or 7. The pleading fails to state a cause of action, and then reading those two provisions in conjunction with subsection G, standards for motion to dismiss in certain cases involving public petition and participation. A motion to dismiss based on paragraph 7 of subdivision A of this section, in which the moving party has demonstrated that the action, claim, cross-claim, or counterclaim subject to the motion is an action involving public petition and participation as defined in paragraph A of subdivision 1 of section 76A of the Civil Rights Law, shall be granted unless the party responding to the motion demonstrates that the cause of action has a substantial basis in law or is supported by a substantial argument for an extension, modification, or reversal of existing law. The court shall grant preference in the hearing of such motion. So here you can see that when a party petitions for a dismissal on the basis that a cause of action or a lawsuit is based on a civil rights protected issue, there is something of a reversal of the burden of proof. It now becomes the obligation of the petitioning party to show that there has been a substantial modification of law, or there has been something that justifies allowing the lawsuit to continue. And the final sentence of this provision, as far as I understand it, just means that the court hears such a motion to dismiss on a preferential basis. Which only makes sense because if you're going to dismiss a lawsuit on the basis that it's violating one's public participation, you don't need to get into a hearing on the merits in order to dismiss it when you can dismiss it right off the bat. This lawsuit strikes at the heart of the news media's First Amendment mission to inform on matters of public concern. In its coverage, Fox fulfilled its commitment to inform fully and comment fairly. As part of that coverage, several Fox hosts offered members of the president's legal team the opportunity to explain their allegations and the evidence they had to support them. Sometimes the president's advocates accepted those invitations, sometimes they declined. As the story unfolded and as Smartmatic denied many of those allegations, Fox covered the denials too, including by reporting Smartmatic's position, offering Smartmatic the opportunity to tell its side, and soliciting the views of disinterested third parties on the veracity of the allegations against Smartmatic, sometimes in a debate-like format. In short, Fox did exactly what the First Amendment protects. It ensured the public had access to newsmakers and unquestionably newsworthy information that would help foster, quote, uninhibited, robust, and wide open, end quote, debate on rapidly developing events of unparalleled importance. New York Times Company versus Sullivan. By now, all of you watching my vlogs should know very well what New York Times versus Sullivan represents. That was the lawsuit that established the criteria of actual malice when suing a public figure. That was the lawsuit that established the criteria of actual malice when commenting on a matter of national interest, and that is to say that when you are commenting on a matter of national interest, when you are commenting on a public figure, if those statements are going to be deemed defamatory, they have to have been made with actual malice. There may well be contexts in which the press may be liable for publishing these statements of third parties, but this is not one of them. The First Amendment provides its highest protection to coverage of and commentary on matters of public concern. When a statement or allegation is newsworthy just by virtue of being made, the press may cover it with full First Amendment protection, for it is the, quote, fact, end quote, that the allegation is being leveled that is newsworthy. The press can interview a newsworthy individual making controversial statements without endorsing everything the interviewee conveys. And the press may cover both sides of a heated controversy without fearing it will be sued by the party who eventually prevails because it also gave the losing party a forum. This is a critical distinction in that it's not because an interviewee says something potentially defamatory on a media platform that media platform can be held liable for defamation. It is not the case that because an interviewee may say something potentially defamatory on a media platform that means the media platform agrees with and affirms those statements. And if media platforms were held liable for the statements made by their interviewees, it would be impossible to cover contentious issues where one party may ultimately lose on the merits. At least that is the argument, and each case is decided on a case-by-case basis, and there may be specific facts in this case that might make Fox News more or less liable, but that is the argument, and it is a good one. Second, the complaint fails to allege that Fox published the challenge statements with actual malice, knowing or reckless disregard for the truth. Smartmatic is clearly a public figure here, and in any event, its claims implicate, quote, the constitutional right of free speech in connection with an issue of public interest, end quote, thus triggering the New York anti-SLAPP statute. Accordingly, Smartmatic cannot proceed past the pleading stage unless it alleges facts proving that Fox knowingly or recklessly falsified its coverage about Smartmatic. Smartmatic's complaint alleges nothing of the kind. At most, Smartmatic alleges that Fox negligently failed to investigate its guests' statements in advance, a theory foreclosed by Supreme Court precedent. Smartmatic's effort to saddle Fox with billions of dollars of liability for covering all sides of a vigorous debate of profound national importance must be dismissed. Fox News then goes on to address the demand for retraction it had received and the invitation it extended to the interested parties to come on its own platform and discuss the disputed issues. On December 10, 2020, Smartmatic sent Fox a letter demanding that Fox retract allegedly defamatory statements about Smartmatic made, primarily by other people, on shows hosted by Bartiromo, Dobbs, and Pirro. In response, Fox invited Smartmatic to appear on Fox to address the allegations made by the president's surrogates. Smartmatic declined. Very interesting, and to pull out a totally applicable meme,
it's a bold strategy, Cotton. Let's see if it pays off for him.
I'm going to post a link to this motion in the pinned comment so you can go read the motion in its entirety for yourselves if you are so inclined, but it contains an addendum which has a bunch of statements allegedly challenging some of the statements made by some of the guests on Fox News. The ultimate point here being that Fox News is saying it did not affirm or assert anything. In fact, it was investigating some of these claims, contradicting them at times, so it cannot be held liable for defamation. And not only that, given the fact that this lawsuit is based on Fox News exercising its First Amendment rights on a matter of national importance, the lawsuit itself is intended to stifle public participation and must therefore be dismissed under the anti-SLAPP legislation.
I demand satisfaction!
And my apologies, I think I have to correct myself. This is in fact not a $1.3 billion defamation lawsuit. It seems to be a no less than $2.7 billion defamation lawsuit. And as the saying goes, when your case is strong in law, pound on the law. Fox News then continues to pound on the law. The standard is even higher when a complaint challenges speech in a, quote, public forum in connection with an issue of public interest. Under New York's anti-SLAPP law, courts must dismiss complaints challenging such speech unless the plaintiff demonstrates that the challenge has a, quote, substantial basis in law, end quote, or, quote, is supported by a substantial argument for an extension, modification, or reversal of existing law, end quote. In other words, in a case involving speech on matters of public concern, the plaintiff must demonstrate that the case should not be dismissed under a, quote, heightened standard of proof, end quote. That standard embodies the recognition that the, quote, threat of being put to the defense of a lawsuit, end quote, may be as chilling to the exercise of First Amendment freedoms as fear of the outcome of the lawsuit itself, end quote. So there is not only a reversal of the burden of proof, but there is a heightened degree of the proof that is required in order to be able to continue with your lawsuit. In other words, the ball is now back in your court, Mr. Smarty Pants. The motion to dismiss goes into further details that we don't really need to get into for the purposes of this vlog. You've got the idea, but just to conclude with the essence of what Fox News is arguing. In short, Fox's coverage of this, quote, newsworthy controversy, end quote, was exactly the kind of expression that the press must be, quote, afforded the freedom to provide without fear of liability. Quote, if the mere fact that a statement is made is itself newsworthy, then the reporting of that statement by the press is protected expression, regardless of whether the statement is defamatory and false, and the press is not bound to verify the truth of the statement, end quote. And Fox News cites an authority, and I have no idea how strong that authority is under New York law. The initial defamation lawsuit essentially alleges that Fox News should be held liable because they gave a platform for people to make certain allegations for which there was, quote, obvious reason to doubt. To which Fox News responds as follows. But the fact that Fox programs pressed guests for evidence and attempted to investigate the allegations as the story unfolded just reinforces the conclusion that a reasonable viewer would readily have understood that Fox was not covering those allegations because it was confident they were true. It was covering them because it was confident they were newsworthy, as was virtually every other press outlet in the country. The logic of Smartmatic's position is that the press must censor all discussion of even the most pressing of public controversies to escape imputation of actual malice, even in the context of statements by objectively newsworthy third parties during live television interviews. This is not and cannot be the law, as the First Amendment could not tolerate such a profound threat to our, quote, profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, end quote. Conclusion, for each of the foregoing independent reasons, this court should grant the motion to dismiss under CPLR 3211 A1, A7, and G, and Civil Rights Law Section 76A. Alright, so think what you will of Fox News. It is a good argument, and it is an argument that doesn't apply equally to all the defendants. In theory, and always depending on the facts, it is an argument that would apply equally to all the media defendants, but not to the individual defendants who are the ones who actually made the statements. So although I suspect the individual defendants could probably also try to raise this anti-SLAPP argument, it certainly seems to be the stronger argument of the media entities and not the individual defendants themselves. We will see where this goes. We did see Keemstar succeed on this very argument, but that was in California. That was in a file that was not politically charged. We are now in New York. We are now in the context of a file that is politically charged, and as I always say,
politics ruins everything.
And if my shirt looks a little dirty, it's only because I spilt a little bit of coffee on it this morning, so to be continued. But if you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below because it feeds the algorithm.
Tina, you fat lard, come get some dinner.
If you want to support the channel, all of the support links are in the pinned comment. Robert Barnes and I do weekly live streams. We have a page on locals, vivabarneslaw.locals.com. But more important than any of that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out. Boom.